we had an incident which involves the media houses, and that caused us to set rules, and those rules apply. And I'm not continuing with this trial with the person who went offending inside. I'm not doing that. That person, whatever the effect and the extent of the footage, that person should leave this courtroom now. If we don't know who it is, all media is going out now.
Indeed, my lord, and at the same time we try not to punish the innocent media houses who are not involved in this. Hence we're trying to establish who the culprit is so that that person can be dealt with once and for all, my lord.
I hear what you're saying, but if you are here and you are a media person and you didn't do it, you must know who it is.
Yes.
I mean, we shouldn't be sold that kind of a dummy of people pointing fingers at all directions just to confuse. If the problem is the media, then let them go out and sort out about who went errant, and that person will remain outside. All those who are innocent will come back.
All right, let's stay with the story and speak to Nthabiseng, Dubazana and Mpumelelo Zikalala, who are both legal analysts. Thank you so much for your time. I'll begin with this part. It looks like Nthabiseng, the defense is trying to render Madlala a discredited witness. Is that the same sense you're getting, and what implications could come from this?
Yes, I do agree with you. They're trying to basically cast a huge shadow of doubt on the evidence that he gave during examination in chief. So what we are now seeing is his credibility being put in question. So for example, when you look at yesterday, the effect of alcohol when he was asked whether he was in his sound and sober senses at all times when the intruders entered the room, that was also put in question because he could not exactly confirm whether or not he was in sound and sober senses. And then today he was further asked on that matter whether his blood alcohol content was drawn for it to be determined if he was under the required limit for having consumed alcohol, and that could not be answered either. So by virtue of that alone, we're trying, I think Advocate Mpumelelo is trying to say that by virtue of that alone, you cannot come to the court and say conclusively that what you saw is correctly what you saw, and yet we're having this question of whether or not you were sober enough to see what happened.
And Khuzeni, how huge is the concession that pictures of the crime scene taken by police may not be a true representation of what the house looked like on the night Senzo was killed?
It's very crucial. Let's remember the burden which has been put to the state, that they must prove beyond reasonable doubt that the individuals that are in the witness box are indeed the perpetrators and the individual that killed the deceased, Mr. Senzo Meyiwa. So if you're going to cast instances of doubt here and there, it then renders the state's case very weak, and it forces the court to then say, I have to rule in favor of the accused in this case. You haven't been able to prove beyond reasonable doubt that indeed the individuals who are in front of me are the ones that should be punished for this very bad and horrendous crime. At the end of the day, it then points to the law enforcement agencies and says to them, did you really apply your mind? Were you articulate investigating officer? Did you collect the information accurately? Did you know what you were doing? Do you understand how evidence is going to be evaluated in court? And when it comes to the prosecution, Mr. Prosecutor, do you understand the burden of proof that you have and the level of evidence that you need to provide? You must bring it up to the table and make sure it is up to par so that you can be able to prove that these individuals are indeed guilty. If you don't do that, then a not guilty plea is going to be rendered, and that's going to have dire consequences for the family and also for the trust that we have in our legal justice system.
And Khuzeni, if I move back to Nthabiseng, particularly on the issue of sobriety, there's also something that the defense it keeps pushing at here, and that is the issue around those pictures that he then gave to Netflix and was paid for those pictures, and then at the same time he says the family knew about this, but then it emerges that the family was never given a portion of this. What could they be driving at here?
They're trying to drive to the credibility of the witness. They're saying, you see, you choose when, as and when you're going to give information, especially when there's remuneration or certain gratification which is going to be received. That's where you open up and you give all the information which is required. Why do that if you're going to do it in the interest of justice and making sure that your particular friend or the person that you regard to as your friend, their killers are known? But most importantly, you are evading questions here in court, even though you are well aware and you want to participate in a Netflix documentary. Here in court, you are evasive and you don't want to share important information, which is going to assist in making sure that justice is indeed brought to the Meyiwa family. So the only conclusion that the court can drive to is that, one, you're not a credible witness, you are telling lies here in court, and your evidence should not be trusted. Again, casting doubt and planting those instances of doubt in the state's case.
Nthabiseng, there's also, you know, when one looks at the issue of sobriety, but also there's another huge one, which, you know, this afternoon they were really trying to really discuss. And this is the issue around his version when he was giving evidence in chief that, you know, Longwe charged towards the men that had the gun and was trying to push, in fact, push that man. But then he still says he doesn't believe that version. It's incomprehensible, because if he had a gun and he was charging towards a man with a gun, the person with a gun would have shot at Longwe to try and scare him off. And his admission, though, it's huge, because he seems to also not be understanding or comprehending how this could have all happened.
Yes, and if I recall correctly, he said also, in addition to that, that even after the incident, he went and spoke to Longwe and said, how did you accomplish what you accomplished? Because according to him, it couldn't have been done. It doesn't make sense how in that situation somebody would have done something of that sort, and over and above that, without getting shot, which is what Advocate Mpumelelo was trying to drive at, that in such a high-paced and high-intense situation, it should have been that a shot was fired to people who were attacking the person who had the gun, inclusive of the 3 females that she kept on mentioning over and over again, when he instead ran to the kitchen to try and escape, where he then found the deceased there and who was fighting somebody whom he's not even sure whether or not that person was armed or not. So that situation in its entirety, that's why Memshololo ended up saying that based on what you're telling us and the probabilities of what you're saying happening, it shows that there was not any intruders in the property on the day in question, which will then leave us to say, is Memshololo going to be driving to the fact that there is a possibility that if there was no intruders on the day in question, that the crime happened with the people who were already in the house, and therefore the witness before the court currently could have been an accessory to the crime that happened on the day in question.
And I suppose, in Nthabiseng, then it brings us back again, if she drives to that point, to that other docket that appears to be put on ice right now.
Yes, 100%, because now, remember, the state has paused it, and that has never happened. I think my colleague will either confirm or deny what I'm saying. When there are 2 dockets that are open, usually what happens is that they are consolidated into one, and then we proceed with all accused persons in one docket. So what happened in this case is very unusual. So now we're having basically an open docket that is waiting for a current trial to end, with all the evidence that is within this current trial to be used in the trial that may or may not happen with the other 7 accused. And then all this information has already been let out. How then do you counter the process of justice not being served by doing so as the NPA?
So, Khuzeni, then what becomes the implication then of this one? Because if this docket again comes into the spotlight, I suppose then the state might be forced then to bring it back and consolidate it if it really does keep on coming up like this.
In fact, it might be too late by the time the state decides to bring back that docket. It's not going to serve any purpose, and it's going to drive directly to the credibility of the prosecutors in this case, in terms of saying, did you really apply your mind when you're looking at this evidence? What ought to have done, as my colleague is saying, look at the evidence at the 2 dockets, consolidate them, even if it means you're going to have 8 or even 10 accused persons. But the type of crimes in which you're going to charge them for, or the charges are going to be different, ranging from actively participating in the murder, or maybe breaking and entering, and even line, which is perjury. So that at the end of the day, you are trying to bring them and prosecute them in one go. You bring the evidence or the witnesses all in one go. You do not run the risk of calling individuals twice, so that at the end of the day, the chances of contradiction themselves are going to be high. Do that so that at the end of the day, you can be able to bring justice and say, in your participation in this particular trial, even though you did not pull the trigger, even though you are not the person that caused the death of Mr. Senzo Meyiwa, you participated in a crime by lying and sending law enforcement officers into a wild goose chase. It should be understood that this is breaking the law and you're going to be punished for that. If you do not do that in this case, you run the risk of not all the accused being brought to book and many of them being let free due to the occurrence of the sequence of events. And at the end of the day, you're going to be left with egg on your face because you're not going to be able to prosecute anyone. So the manner in which this child prosecuted is really something to be looked at.
As a final question then, Kuzeni, in about 20 seconds, the media being kicked out again. We saw this happen before when there was that chasing down of Tumelo Madlala. Now again, the media is out again. Do you think that the judge might be persuaded here to have everyone back?
I think the judge must be persuaded. I think that was a very harsh move. I think the real perpetrators should be found in terms of the people that were chasing down the witness. Secondly, if you're not going to allow any visual, maybe broadcasting of the trial, at least allow audio. At the end of the day, if you look at our constitution, it's very clear as to the open court policy. And that open court policy, even case laws states, even includes access by the media so that even I sitting in Durban will have access to know what is happening within that particular court. I think maybe after some persuasion, after some precautionary measures are put in here and there, the media can be allowed to come back, even if it's simply audio and there are no visuals which are going to be taken of the proceedings.
All right. So thank you so much to you both for your time. Do appreciate it. Let's see how this one unfolds. That's Nthabiseng, Dubazana and Mpumelelo Zikalala, who are both legal analysts.